Hey.
All right, so I'm Jerusha Hancock. I'm the head of the VA practice here at Berry Law Firm, and Seth Chambers is with me. He's one of our non-attorney advocates. We came to talk to you today about evidence that you can get to support your claims for VA benefits.
Yep. And we brought the bazooka with it because we're about to blow this up. So if you guys have any questions, please message them below. And then other than that, we'll just get started.
Yeah, so basically the two kinds of evidence, if you want to think about it this way, are evidence that's internal and evidence that's external. So if you're talking about internal evidence, that the VA would have, and that includes service records, personnel records, medical records from your time in service, anything that is going to be owned or contained by the VA. That also may include, if you are a National Guard member with active duty service, that might include line of duty reports, if you were injured while on active duty training, that sort of thing. So, Seth, what do you, as somebody who's in the reserves right now, how would you go about getting those records?
So, I mean, the first thing you can do is, you can submit an SF-180 for those records, but as your duty for records keeping in the reserves is a lot different than being active duty. Because when you're in active duty, you go to medical, they take every single thing that you do in your active duty service and it goes into your medical record and it all counts. So I'll give you a perfect example of this. Last year I was on drill and we were down in New Orleans and we were on a run and I twisted my ankle. And I specifically went to the corpsman and asked them about what do I need to do. So what I did to cover myself was I went to medical, got it documented that I rolled my ankle while on duty, and then I said, well, can I get a light duty chit or a limited duty chit to prove that the injury that I suffered from happened on drill orders. Because if you are trying to claim something for VA benefits while as a reservist, it has to be during a period of active duty. So if you went on deployment or if you injured yourself on drill, then you have to get it documented, get a line of duty chit that says that you were injured on that drill period and that now injury has continued to, that you still suffer from that. So in my particular case, they said, well, if this doesn't manifest into anything, then you don't need anything, but you got it documented. But I at least had to prove that I had that there. So then in that case, you would need to get copies of those records while you were there. So I took copies and made copies and put it in my medical record and had them there. So being in the reserve definitely makes it more difficult, foot pain or shoulder pain or any of that kind of stuff documented, because you have to be more diligent to do that as you are as part of your reserve duties.
So that's really good information for folks that might be watching this who are still in the National Guard or who might still be on the reserves. Think about this stuff as you're doing drill or as you're doing your deployments, and make sure that you're getting those documents, because service medical records are one of the primary things that the VA looks at in order to determine whether or not something can be service connected. Yep. So, if you're on active duty or if you're in the reserves or in the Guard and you're on active duty for training purposes, make sure you're getting those things documented. Go to medical, get it written down. You're going to be much, much better off in the future if you do.
Yep. Which actually, before you did off that point, that is how the VA service connects. The VA needs 3 elements for a service connection. They need documented evidence that the event happened in service, and they go to your medical record for that. Then they need a current diagnosis that you still suffer from that issue, so you need the diagnosis, and then the nexus between the two. So if you don't have it documented, it becomes very difficult for the VA to legally go back and say, this is our fault. Because if you got injured, wouldn't you go see somebody while you were in service? I mean, that's kind of the logic there is, I was injured in service. Oh, okay, great. Well, then show us proof that you were in service and got injured. And if you don't have it documented, you just say, well, I just rubbed some dirt on it. Well, that only goes so far when you're talking about money. which is what the veteran wants the government to do. The veteran wants the government to pay them for their injuries.
Right.
So the veteran has to produce or be able to say with some kind of, validity, hey, this is how I got it, this is where it came from. And getting it documented in your medical record is the first step to doing that.
But unfortunately, most of our clients,
this is true,
didn't get this advice before they went on active duty or when they signed up. Mm-hmm. And we all know those folks who will not go to the doctor even if their arm has fallen off. Mm-hmm. So at that point, if you're out of active duty service and you're going to make a claim for benefits, at that point you need to figure out what kind of evidence can you get if it's not documented in your service medical records, or if it is in your medical records, but maybe there was a big gap between when you separated and when you first. I'd say that there's really no connection between the two. I don't know how many clients I have had who do have documented injuries being in service, but then didn't have medical insurance after they got out. Mm-hmm. And so didn't go see the doctor, didn't have any kind of medical treatment for things like a back condition. And then as time went on, it got worse and worse and worse. And suddenly, they have to prove that it did happen in service, or that there's some connection between their current disability and the incident in service. Mm-hmm. And so we're going to talk a little bit about what you can do and what you can gather in order to prove your claim when you are in that boat as well. So one of the things that's probably the most powerful tool for a lot of our clients are what's called buddy statements.
Yep.
Buddy statements can be from buddies that you had while you were in service. They can be from a friend, a family member, somebody who knew you at the time and knew you were injured, somebody who's known you since your time in service and can talk about how the last 20 years you've had horrible back pain, and that you didn't have medical insurance and so you weren't able to see a doctor. That's one of the ways that you can bridge the gap between either not having any medical records from your time in service because you didn't go to the doctor, or because they were lost or destroyed, and how you can bridge it between current day and your current level of disability. Mm-hmm. The things that you're going to need are a statement that comes from that person in their own words. You don't want to write it down for them. They need to be able to talk about it from their own perspective. They need to have detail, things like how they know you, how long they've known you, what they've seen with their own eyes. Unless they have a medical degree, they can't really talk about it like they were your doctor, but they can talk about it like they were your friend or family member. So, for example, for one of my clients who had a back injury in service and then they lost those records, his wife talked about how she had joined him in Germany and she was with him in the hospital after he had the car accident that caused the back injury. A buddy statement like that can be very effective in showing that there's some connection to service when there are no medical records or when they're missing.
Yeah, and I knew a guy who was in the Marines. He was a tank officer, and he put in a claim for back pain, and then they looked up his medical records, and they said, "You didn't go to medical one time for back pain?" And he said, "Well, that's because our company commander wouldn't let any of the officers go to medical." But he was able to get a buddy statement from that commanding officer that said, "I refuse to let any of my officers go to medical." And that one statement covered everything. It explained the entire thing, because it says you will not find medical records because I'd forbid him from going to medical. So then when he was out of service and all of a sudden started having all this, back pain and stuff that was already there, they service connected.
So buddy statements can be very helpful. Now, a lot of people, especially our older clients, may not know anybody that they knew while they were in service, or maybe they're not in touch with friends or family members that can help them write a buddy statement. one of the things that can be done then is getting an independent medical opinion. So these can be a little tricky to get. Number one, you have to find a doctor who's willing to provide one to you. And that sometimes can be difficult. So, keep that in mind when you're searching for a doctor. You want the doctor to be able to say that they've reviewed your records, whatever records are available to them, that, it's in their medical opinion that your condition is at least as likely as not related to service. And then to offer an actual rationale for why they believe that. So that could be anything from a psychologist giving you a PTSD diagnosis and relating it to maybe an unreported assault that you had while you were in service, to looking at your back x-rays and saying, yeah, I think that this was more likely than not caused by service because, he's talking about a chronicity of symptoms and we know, we can expect degenerative changes to look like that over the last 40 years. It probably started, 40 years ago. Whatever the doctor can say on the record as far as getting you service connected.
And in to that point, the doctor doesn't have to say that they firmly believe that this is the cause. All the doctor's opinion has to say is that it is as likely as not. It's 50-50. It's just as much possible as just as much not possible. It's not that the doctor has to put themselves out there to say, I 100% believe that this is the cause. The statute is that it only has to be as likely as not. I mean, if it's 50%, not 51%, but just 50%, the connection goes to the veterans. Tie goes to the runner in the veteran's favor. So it's something really good to remember if you are the veteran going to your doctor and the doctor's like, I don't know if I want to touch that with a 10-foot pole. Hey, if in your medical opinion it is equally as possible as not possible, that's all you're asking for is,
right.
Is it possible? If it's yes possible, then get them to say that.
And if you put it that way, there's probably going to be more doctors who are willing to provide that statement for you. Mm-hmm. So buddy statements, service records, independent medical opinions, and then one of the things we haven't talked about yet are all of the other little things that you might have in your attic. So those can be awards and decorations, medals. Maybe if you're an older veteran, you served back in the Korean War, the Vietnam War, maybe you wrote letters home and somebody kept those. And you talked about events that happened while you were in service or while you were in country. Maybe if you are a younger veteran, you might have had social media posts while you were overseas. You might have photographs from your time overseas, especially if you want to show that you were exposed to burn pits. One example that is pretty fascinating was a Vietnam-era veteran who was attempting to get service connection for a particular back condition that causes a hump. And the VA refused to service connect him until he dug up a picture that showed the beginnings of a hump while he was in Vietnam. At that point, they had to service connect him because clearly he was starting to suffer from this particular degenerative spine disease while he was on active duty service. So, we often encourage our clients to raid the attic or to talk to friends and family members that you were communicating with while you were in active duty, because they may have kept some of those things as well. I had a client get service connected for PTSD because he wrote his mom about his stressor back in the 1950s, and he was able to dig that up out of the attic, and it was clearly an old note, and it clearly communicated what the stressor was, and it was contemporaneous to the event, and so he was granted service connection for a mental health condition. So there are all kinds of things that you can use. It's great if you can think outside the box. Think about things that you've collected, that you sent home, that you posted on Facebook, that maybe texts to a friend, all kinds of things. Just really think outside the box. Think about what you might use. to go back to, the not going to medical, well, you might not have gone to medical, but maybe you had a Facebook post talking about how sore you were after a run and how your back hurt or something like that. You just never know, and those sorts of things can be really helpful. And then I think probably we want to talk about one of the big ones. One of the things that a lot of our clients want and need is a total disability rating based on individual unemployability, and how you can get that claim granted. Sometimes it's really easy. Other times it is very difficult. And so basically, if you qualify for a 100% rating based on your disabilities, that basically means that the VA has conceded that you have service-connected disabilities that don't allow you to work, and so they will pay you as though you're 100% disabled, even though your combined total rating is less than that.
Should we really quick explain what that is, just so anybody doesn't know?
How do you mean?
So, like, in order to even qualify for TDIU, you have to have one disability at 60% or a total disability rating of 70%, with one disability being at 40%. So that we do see some people that would like to get 100% disability or the TDIU, but they're only at 40% total, or they're only at 50% total with some 10s and some 20s, but they say that they can't work. So the first step in that process would be to file for increases on the disabilities that they are connected for, to get them up to what the VA's minimum requirements for TDIU. Because getting denied for TDIU could be just because you don't meet the requirements. It couldn't, might not have anything to do with your disabilities. It may just be that your disabilities aren't enough. Because we do have a couple of clients who are in that ball of wax where they have a disability that's at 50%, but that is the one disability, and one disability at 50 isn't enough. So just...
That is true. So essentially, in order to prove that you are unable to pursue or maintain what's called substantially gainful employment, and all that means is that you can't work enough hours at a location to get you above the poverty line. So if you're making below the poverty level, which is around $12,000 for an individual, and then increases by the number of dependents you have, you may, and you're service connected high enough, as Seth just explained, you may be eligible for a total disability rating. Now, the VA is going to ask you about your last 5 years of work. They're going to check with your prior employer or employers, and then the question becomes, is it your service-connected disabilities that are preventing you from working? And the VA can be reluctant to give you a TDIU. And so the best way of coming up with this is to show, number one, that any jobs that you left prior to becoming unemployed, you left or were fired or laid off because of your service-connected conditions. If you've got PTSD and you are not a real fan of authority, and you got booted a few times from different jobs because of your PTSD symptoms, that would be really good to get on the record. Statements from you, coworkers, former supervisors, that sort of thing can be very helpful. If you've had a lot of different jobs, because it's really hard to keep one, records of that. If you were let go, or if you had poor performance evaluations, if you can get those copies of those records, that's going to be very helpful as well. In some situations, if you've applied for voc rehab and you've been denied because they say that there's no way you're going to be able to work or go to school full time, get those records. Those can also be very helpful to your claim. And then finally, if you're really struggling, what you can do is contact a voc rehab specialist, and they will give you an assessment as to whether or not you are able to do the job for which you've had the training and the education and the experience in. So if you have a lot of physical disabilities and your job before was labor, heavy labor intensive, like construction, plumbing, electrician, that sort of thing, having somebody say that you physically can't do those jobs anymore and that you don't have the training and qualifications for a sedentary job could be very, very helpful if you can't get TDIU any other way. But those are the things you're going to need in order to show that you're entitled to that total disability rating.
Yeah. And I remember when I used to work at the VA processing claims, we would have to reject some TDIU claims because veterans would send us the TDIU form, and it says the last 5 years that you worked, and they'd be like, well, I haven't worked in 5 years, so they wouldn't put anything down. Then we'd send the VA would send the veteran a letter asking for those records. The veteran wouldn't give us anything, then the claim would get denied. So it's very important to put down the last 5 years that you did work, even if that last 5 years was more than 5 years ago, because what the VA is doing is they want to send a letter, as Jerusha said, to that employer. So they need to be able to send something to somebody to get some records to say either we do not know this person, or yes, this person was fired for cause because they don't respect authority, something. That's why filling out those forms in entirety is very important. I just want to stick that in there because I have seen claims where the veteran has had a completely legitimate claim and the VA will deny the claim because the paperwork wasn't filled out correctly. So.
And that is absolutely true. The other thing to keep in mind is I've had a fair few clients who do not want anyone contacting their previous employer because they left under a black cloud for whatever reason. And if that's the case, then a statement from you, a friend, a family member, a coworker who's still friendly, something like that, who can say, yeah, things got real bad there for a while. My employer, especially with mental health claims, if your employer, didn't find reasonable accommodations for you or treated you poorly because you had PTSD or something like that, a statement from you can be very helpful in letting the VA know, hey, I had to leave this job because of my PTSD, and if you contact my employer, they're probably not going to be very nice about it. So you can kind of help your case out that way too. And once again, statements from friends, family members, coworkers, former supervisors, just people who can speak to what they saw and witnessed. If you have records that show that you took a lot of time off work, you took a lot of sick leave or FEMLA leave, the Family Medical Leave Act, that sort of thing. Sometimes there will be a formal finding that you did request accommodations under the Americans with Disabilities Act. And if that's the case and your employer couldn't reasonably accommodate you, that could be very helpful evidence as well. So there are all kinds of things that you can use to help you with your claims. The last thing I want to touch on, and we talked a lot about service medical records and how important they are. I do want to highlight one thing that the VA often gets wrong, and that is if you are a combat veteran. You have to show proof that you were deployed to a combat zone. So if you have a combat action badge, combat infantry badge, that sort of thing, a combat action ribbon, something that shows that you engaged in combat. The evidentiary rules are loosened. So if you are a combat veteran and you injured your shoulder, then you can say, hey, I injured my shoulder while I was deployed to Afghanistan. We were in this firefight and I wasn't able to go to medical and I just lived with the pain since then. Well, they don't need to find corroborating evidence in your service medical records in order to service connect you. It just has to be consistent with the trials and tribulations of combat, essentially. So if you can make that make sense to somebody who's doing your rating, they don't have to look at your medical records and, in fact, aren't allowed to deny your claim simply on the basis of no corroborating service medical records. So that's an important caveat, and if you've been denied by the VA and you're a combat veteran and you think that this applies to you, this is a really good opportunity for you to contact us and let us help you fight that battle with the VA, because there's a lot of different rules, evidentiary rules that we can't cover today, but that might apply to you and that we can help you out with.
Yeah. Well, I think we had a really good discussion today. It feels a lot better being in the new building with the new space and stuff like that. So, I mean, better than we had before. I'm glad we brought in the bazooka. I thought that was a nice touch, too. So, any other final comments before we say goodbye today?
Nope, I don't think so. I hope everybody has a great weekend.
Yeah, hopefully don't get snowed in here in Nebraska.